This is Owen Casey from the School of Criminal Sciences at University of Lausanne, presenting Structuring the Evaluation of Location-Related Mobile Device Evidence. Mobile devices are increasingly being used as a source of evidence in criminal investigations. The question of whether the device was at the crime scene during the period of the offense is a complex question that requires consideration of alternatives and a strong scientific framework of evaluation. Forensic evaluation has three principles. The first is that the evaluation is conditioned by a framework of the circumstances of the case. The second is that the evidence must be evaluated given at least two competing hypotheses. And the third is that we evaluate the evidence in light of hypotheses and task-relevant information, not evaluating the hypothesis. To better understand this problem, let's consider a specific case. In a homicide investigation, the victim's body was recovered from a river, and forensic analysis of the prime suspect's mobile device recovered location-related evidence that correlated with the location where the body was found. This evidence was presented in court as an indication that the suspect was at the location when the crime was believed to have occurred. In this case, the defense challenged the accuracy and the reliability of this location-related evidence, and the judge agreed and did not accept the evidence. The judge's decision not to admit the location-related mobile device evidence in this case was largely based on the lack of a scientific evaluation of the evidence. Elénore will discuss the accuracy of this type of evidence.
There are three different types of technologies commonly used by a smartphone to localize its position: the geosatellite network, the cell phone network, and the Wi-Fi network. Other technologies such as Bluetooth and phone sensors can be of use. All these technologies provide a different accuracy. Without any interference, GNSS can provide an accuracy of 5 to 10 meters. Cellular networks make it possible to target an area with a variable diameter, generally greater than 100 meters, depending on the generation of technology being used. Localization using Wi-Fi networks allows an accuracy of 30 to 75 meters. An application might request two types of localization, a precise and a coarse one. The method used by a phone to locate itself will depend on the technologies, hardware, and software available. The information the phone can receive from the network, the user choices, type of movements, as well as the external environment will have an impact on the localization. In Switzerland, the reflection of lakes has to be taken into consideration while analyzing cell tower connections, as phone can connect to a distant antenna rather than a close one. This is one example of influence on accuracy, but distance from a network, signal strength, signal direction, atmospheric conditions, and obstacles can interfere with a mobile device's ability to obtain location-related information.
And now Hannes will discuss how to structure a forensic evaluation.
So how are we going to structure evaluation? Well, we are going to start by clearly defining what possible explanation we consider for the traces at hand. We are going to state them as hypotheses, also named propositions, and we're going to structure them in a way that clearly states what we mean by them. Those statements are versions of what might have happened, and they are, per definition, either true or false. Also, all hypotheses considered have to be mutually exclusive, so if one hypothesis is true, all the others that we consider have to be false. Of course, we don't know which ones are true, which is true and which ones are false. This is the whole idea of the analysis. In a second stage, we're going to in turn suppose that each hypothesis is true and then explore the universe that is created by that. This is an imaginative universe and in which we're going to search for predicted observations. Within the scope of location-related evidence in smartphones, there are three types of hypotheses that are regularly observed, and we're going to take a look at them a bit in more detail now. First of all, hypothesis 1, generally the hypothesis presented by the accusation. It's quite simple. The device is operating at location X during time T. So, three elements of this are worth mentioning. First of all, we're talking about a device, we're not talking about the person. They may be separate, they may be together, we don't know. Secondly, we're talking about location X. Location X in this case is our crime scene, or the place where an event took place, the environment in which an event took place, and we are not restraining its size. We are considering that it is more or less homogeneous in regards of the location-related evidence we're looking at, but this is mostly to simplify the mathematics later on. There is no reason this wouldn't have to be the case. And third, we have a temporal restraint during the time t. We are looking at a given moment in time, and since any device may be moved, it is necessary to restrain this. We are not going to pronounce on where the device was before t, and we're not going to pronounce where the device was after t. So as stated before, we need to have an alternative hypothesis, at least one, and this generally is the defense hypothesis, and there are two types that you may encounter. First of all, you may find a hypothesis in the form of the device was operating at location Y, distinct from X during the time interval T. Now, location Y is a location different from X. It's a precise location, and this is basically what you see when the accused has presented an alibi. For example, the accused may have stated, "I was at home alone with my phone," in which case we will be looking at this kind of hypothesis. And then third, the device was operating elsewhere during the time interval t. This is a somewhat annoying hypothesis because it's basically like hypothesis 2 before, but location Y is anywhere but X. This is somewhat complicated to assess because it may be very, very difficult to state how likely it is to observe a given piece of evidence, assuming it might have been anywhere on the planet but one location. For both hypothesis 2 and 3, you can observe that we're talking about the same device and we're talking about the same time interval. Those two do not change. The only thing that's changed is where this device was during this interval.
Now let's consider an example where the defendant claims that he was elsewhere with his phone at the time of the crime. In this case, the victim's body was found in Geneva, but Mr. A, the suspect, claims that he was in Zurich at the time of the crime. The telephone records and the data on his device indicate that his mobile device was active and there were outgoing calls and messages sent, indicating that Mr. A was using his phone during the time of the offense. And the observed evidence looks accurate, placing the device in Geneva during the relevant time period. Evaluating these traces under two hypotheses, the prosecution hypothesis that the device was operating near location X, the crime scene in Geneva, during the time of interest, and the defense hypothesis that the device was operating near location Y in Zurich during that time. The evidence is that the device was active near location X in Geneva at the relevant time, and the observed location-related evidence on the device itself and on the telecommunication systems are compatible with the device being near location X at the relevant time. Evaluating the evidence under those hypotheses, assigning a conditional probability that is very large to the evidence under the hypothesis. Evaluating this evidence, the forensic examiner assigns a very large probability to the evidence under the hypothesis of the prosecution, and assigns an extremely small probability of the evidence under the hypothesis of the defense. This extremely rare event, the possibility of the device having been active in Zurich without leaving any trace, creates somewhat of an imbalance and a difficulty in computing a likelihood ratio in a numerical value. However, the value could be communicated verbally. For example, the verbal expression could be the extreme probability, the extremely more probable conclusion. The extremely rare event, the extremely small probability of the evidence under the defense hypothesis creates an imbalance in the computation of the likelihood ratio from a numerical perspective. The assigned probability being extremely small under the defense hypothesis creates somewhat of a problem when calculating the probability being extremely small. The probability of the evidence being extremely small under the defense hypothesis creates an instability in the equation for calculating likelihood ratio numerically. Because of such a rare event, the possibility of a mobile device being active in Zurich without leaving any trace, this rare event having such a small probability means that the division is almost by zero in this equation. The possibility of communicating the evaluative opinion is perhaps dangerous in a pure numerical likelihood ratio. However, this can be conveyed verbally or as a minimum value, favoring the probability of the evidence under the defense hypothesis being extremely small. This would be the device being active in Zurich without leaving any trace, creates an imbalance or an instability in the computation of likelihood ratio numerically. This is because the extremely small probability is dividing almost by zero. Communicating this balance of probabilities could be done verbally, or it could be done as a minimum numerical value to try and stay away from the extremely large ratio, the instability of dividing almost by zero. And in this case, we have a situation where the likelihood ratio is perhaps better conveyed verbally with some care and explanation about the nuances of the traces. Considering another example of a case that was treated previously in a DFRWS presentation in 2016, the defendant claimed that he was elsewhere at the time of the crime without his mobile device, so there is no location-related mobile device evidence during the time of interest. This evaluation under the prosecution and defense hypotheses, whether the mobile device was operating near the relevant area at the time or not, or whether the defendant was near the area of the crime scene during the time of the offense or nowhere near the crime scene during that time, depends on the circumstances of the case, specifically whether the crime was premeditated or not. If the crime was premeditated and the offender took measures to prevent location-related mobile device evidence from being generated, then the prosecution's hypothesis and the defense hypothesis are valid. There's no value in the evidence under either hypothesis. In this situation, the likelihood ratio is 1. If we assume that the crime was not premeditated, the defense hypothesis has the evidence has a evaluating the evidence in this case depends on whether the crime was premeditated or not, whether the offender took measures to prevent location-related mobile device evidence from being generated. If the crime was premeditated, the lack of mobile device evidence is the equal probability under both the prosecution and defense hypotheses. This is a likelihood ratio of 1, and the evidence is not helpful to reaching a decision in this case. However, if the crime was not premeditated, the defense hypothesis that there should have been mobile device evidence detected is favored in this assessment. The likelihood or probability. However, if the crime was not premeditated, then the evidence, the lack of mobile device evidence in this case, is more probable under the defense hypothesis. In this instance, the likelihood ratio of the defense hypothesis. However, if the crime was not premeditated, the lack of mobile device evidence, in this case, is more probable under the hypothesis of the defense by a factor of approximately 10 relative to the probability of the evidence under the prosecution's hypothesis. So this likelihood ratio of 10 in favor of the defense is significant. The offense level proposition that Mr. A was the person who threw the hand grenade in this case versus that some unknown person threw the hand grenade at the victim, that Mr. A had nothing to do with the incident, being the defense hypothesis at the offense level, depends on whether the crime was premeditated or not. If premeditated, then E is uninformative. If premeditated, then E is uninformative. The evidence is not helpful in reaching a decision at the offense level. However, if the crime was not premeditated, then the evidence is in support of the hypothesis proposed by the defense. If, however, the crime was not premeditated, then the evidence supports the defense hypothesis, in this case, for reaching a decision at the offense level. This example clearly demonstrates the importance of considering the context of the crime when evaluating the evidence under the hypotheses presented by both sides. In conclusion, forensic evaluation must be performed on location-related mobile device evidence in order to provide transparency and balance, and to avoid mistakes and misinterpretations. This forensic evaluation process must abide by principles of scientific interpretation and a framework that is here supported by the case assessment and interpretation model in order to assign conditional probabilities to the evidence given each hypothesis with consideration for the case-specific circumstances. And the outcome, the expert opinion in the case, can be expressed verbally or numerically as relative probabilities of the evidence under the opposing hypotheses in consideration of the circumstances of the case. Thank you, and have a good day.